The key risk is under the Suicide Act, as you identified. So Section 2 creates a criminal offence of doing an act which is capable of encouraging or assisting a person's suicide or attempted suicide. And all you need to do is intend to encourage or assist them. And that is, there's no statutory defence to that offence, and it carries a sentence of imprisonment of up to 14 years. And so the implications are quite significant.
Increasingly, we see international estates and assets held not in this jurisdiction. And so whilst we can obviously advise about the rules here, it's also very sensible to be getting advice in the local jurisdiction where the assets are held. So if you have a property in France, for example, then getting local advice from a French solicitor is also incredibly useful, because you might get an order here and you might be thinking, great, I've ticked all my boxes in England and there's no further action here, only to find that the French have their own system, which they do. And then you're going to be going through the similar process in wherever those assets are held.
Today we're discussing the case study of a UK resident individual considering ending their life due to the onset of motor neuron disease. I'm joined by two experts to discuss the case. I'm going to set up that case in a moment, but first I'm going to come for a brief introduction to my two guests, starting with you, Sophie.
Hi, I'm Sophie Wood. I'm a partner in the criminal litigation team at Kingsley Napley.
Thank you. And Laura?
My name is Laura Phillips. I'm a legal director in our dispute resolution team, but we specialise in contentious estates and trust work.
Thank you. So just to set up the case we're going to discuss today, we have the case of Robert Hartley, who's 67. He's been diagnosed with motor neuron disease in early 2022. There is a relatively slow progression, but significantly deteriorating after 18 months. Without Carol's knowledge, Robert researched Dignitas online, made contact, and was accepted with appointment dates provided. Carol, who is Robert's wife in a second marriage, supported Robert's wish to die at Dignitas, booked flights, hotel, and accompanied him to Switzerland. Robert was unable to travel alone. Robert died peacefully, cremated in Switzerland. Carol returned to England. Robert's children from his first marriage were kept uninformed at his express request. He feared they would intervene. What happened next? Well, 10 days after Carol's return, police contacted her following an anonymous complaint questioning Robert's capacity. Carol was investigated for assisting encouraging suicide, which is an offence under Section 2 of the Suicide Act 1961. There was a home visit, interview under caution. Carol gave a full statement. Police eventually took no further action, but the process lasted months and caused significant distress. Carol has not taken independent legal advice before travelling. The estate included French property and a joint investment portfolio. Robert's adult children raised the forfeiture rule. Carol was unaware that a conviction is not required for forfeiture to potentially apply. Relief was eventually granted, but only after contested, costly and distressing proceedings. So, to my two guests, is this a kind of common scenario that you're seeing at the moment with clients you're advising?
Yes, to the extent that this scenario is common, it's still, I suppose, relatively rare, but it's certainly something that we are seeing in the cases that we're advising on.
Thank you. And Laura, are you seeing more inquiries, people aware of Dignitas in Switzerland and in the sort of common psyche?
Yeah, I think it's more topical at the moment because of the legislation that's going through at the moment and has just been reintroduced by the MP Lauren Edwards. And so it's always going to be in the press. There's a lot of sort of media surrounding these kind of issues. And so it is something that is being raised, even it's quite a limited scope of client that it applies to, but it is something that is in the forefront of more people's minds, I think.
And from those basic facts, I mean, what are the key things that led Carol into this distressing sort of position and episode that she's been through? What do you think this kind of case illustrates gaps in awareness on?
I think for Carol, and the situation that she found herself in after coming back and having to face a police investigation, the sort of the key takeaway for me is, maybe I'm saying this as a lawyer, but if you take early advice in these cases, generally speaking, you can avoid having a prolonged investigation after you come back, which just allows you to engage and embrace the grieving process that will happen in any event.
And at what kind of juncture might that take place? Might it be when Robert, say, is exploring it, Carol becomes aware of it, at that point they need to, like, look, when do you tend to find you get brought in the process?
So it depends, because a lot of people don't realise that they can or should seek advice early. But for those that do, generally speaking, as soon as they are put on notice by their loved one, because sometimes it can be sometime after the loved one has decided to die at Dignitas or has made this decision, it's at that point that we're contacted and we then start advising them about their risks in my space under the Suicide Act, so criminal litigation risks. But we work alongside our dispute resolution colleagues in order to ensure the process is joined up, because that's what eventually you want. You don't want the criminal process to be dealt with and then have residual issues with probate or possible civil issues.
And Laura, I mean, what do you think this case highlights at a high level? What do you think? How do you think Carol finds herself in this position?
I think it's difficult because I don't think perhaps people necessarily realise there is no need for a sort of criminal conviction to lose your inheritance. And obviously at this kind of really challenging time, you're not thinking about, will I get the house, or are we going to have any problems getting probate or administering the estate and so on. And so I think that it's when you're automatically caught up in that really difficult process and you're wanting to grieve, the very last thing you want is then to be coming to a lawyer at that stage and saying, well, hang on a minute, I didn't really realise what was going on and I didn't think that this was going to be an issue. And now how do we go about getting relief from whatever civil remedies might be being pursued? Because really all somebody wants to do is get on with their life at that time. And I think that that's probably an issue that Carol might not have identified, and that the range of possibilities that arises in.
And disputes, I guess, amongst the generations or children and different marriages, and often adds another dimension, doesn't it? I imagine, in the cases you work on.
Exactly. I think you can probably see issues arising more commonly where you have blended families or sort of second marriages, where there are issues with sort of, perhaps even you hadn't realised that there was issues with children and stepchildren and things like that. But yeah, more complicated family setups, I think, is probably more common.
And particularly where there's a lot of wealth or assets
absolutely
at stake.
Absolutely.
Yeah.
I think, money and blended families give rise to lots of issues traditionally, especially when there's death involved. And I think that is the more money there is to fight over, the more contentious it can become. But also, where there are charities involved, where there are minor beneficiaries and so on, it doesn't just have to be blended families. It can be, even when there is a relatively small pot to be fighting over, people tend to be a bit more aggressive when it comes to fighting the small pots as well.
And Sophie, just coming to some of the detail, looking at the scenario, I mean, what are the key criminal risks for Carol here?
So the key risk is under the Suicide Act, as you identified. So Section 2 creates a criminal offence of doing an act which is capable of encouraging or assisting a person's suicide or attempted suicide. And all you need to do is intend to encourage or assist them. And that is, there's no statutory defence to that offence, and it carries a sentence of imprisonment of up to 14 years. And so the implications are quite significant. In terms of what amounts to encouraging or assisting, has been grappled with by the courts, because it's really fact specific, which is where our role often comes in terms of advising clients of what the law says, so that they are aware of what they could or could not do in terms of what the law says. There are two key cases here. The first is the High Court case of Ninian from 2019, and that involved Mr. Ninian, who had been diagnosed with a progressive degenerative condition and decided to die abroad by suicide. His wife, Mrs. Ninian, initially wasn't aware of his intention, but became aware and was opposed to it. But out of pure love for him, did assist him in the process of gathering paperwork, completing paperwork, and assisting him to travel to Switzerland, which he wouldn't have been able to do without her. And she did it out of pure love for him. Obviously, she didn't want him to die, but she also loved him enough to respect his wishes. And it was a civil case, but the court looked at whether her actions were capable of assisting or encouraging her husband's death by suicide. And the court found that they were capable. You then have a later case of Morris, which was a 2024 case, again involving a person who wished to travel to Switzerland to die and the possible implications for family members. And in that case, Mrs. Morris was accompanied by her husband, her 2 adult daughters, and her sister. And the court was looking at, in particular in that case, whether the mere presence of Mrs. Morris's daughters and her sister at the clinic in Switzerland amounted to encouragement or assistance. And the court actually found that merely accompanying a person to Dignitas wouldn't automatically amount to encouraging or assisting. It was always fact specific. And the court found in that particular case, they didn't encourage or assist Mrs. Morris. In fact, they were encouraging her at all stages to not go through it. That was their desire, that she lived. And they were there as comforters, they described it. So it's very fact specific. The court is grappling with very difficult circumstances, and it tries to, it's an objective test, but it tries to understand the facts and whether a person's actions actually were capable of encouraging or assisting a person, or whether they just were there to support a person.
So in this case, Carol does support Robert going to Dignitas. How would this be dealt with then by the police and the courts? How would that case be relevant in this context, or what would you be talking to Carol about there?
So Carol, in this case, is probably more aligned with the Ninian example, because she does, clearly Carol's husband is unable to do this himself. So she needs to help him. And therefore she's doing acts where the acts that she is doing are capable of assisting her husband. In terms of how the police and the prosecution service deal with these cases, they are incredibly sensitive, and they understand that they are highly emotive cases. And the police have their own guidance document, the College of Policing. It's available online. And then similarly, the Crown Prosecution Service have a very detailed guidance. And what they effectively do is look at the facts of every single case, and they look whether there is enough evidence to demonstrate that there is an offence, or possible an offence there in the first place. But then, in order for Carol to be charged, the CPS would have to consider not only is there sufficient evidence, which means is there a realistic prospect of conviction, but even if there is sufficient evidence, whether it's in the public interest to prosecute her. Now, often in cases where there is sufficient evidence, there will be a public interest in prosecuting someone. But the CPS recognise that in these sorts of cases, often there isn't public interest to prosecute a person. And there are a number of factors listed. For example, a person did it out of pure compassion for their loved one, or the person who died has demonstrated that they had a very clear, a voluntary and settled decision to die in this way. So our role is, when advising people in this space, is to talk them through those factors and make sure that any witness statement that we draft for them in advance or afterwards makes clear that they fall squarely which people will, within that category of people that it's just not in the public interest to prosecute them, even if there is sufficient evidence to prosecute.
Thank you. And Laura, looking at the civil implications, where do we stand there?
So there is something that we call the forfeiture rule that is essentially set out in the Forfeiture Act 1982 that says that it's a matter of public policy that somebody who has sort of aided in killing someone or taking their own life shouldn't benefit from their estate, effectively shouldn't receive their inheritance, and that's on public interest grounds. That was extended then by Section 2, which goes so far as to say that somebody who has unlawfully aided, abetted, consulted or procured a death also shouldn't benefit from their estate. And so crucially for the civil proceedings, it's not essential to have a criminal conviction. So you don't necessarily have to be convicted by the criminal courts to still lose your entitlement and have your benefit to someone's estate forfeited. So the Act goes on to give the court the chance under Section 2, if you like, to be able to say, actually taking into account all of the circumstances, they can set aside the forfeiture rule when they take into account lots of different factors. And they've Sophie touched on a couple. There have been a couple of cases that have actually been heard in the civil courts where, a couple who had a suicide pact, but only one of that couple went on to pass away. The other person had an application, set aside under the forfeiture rule because of a number of factors that the court take into account when they're reviewing this. And many of those include things like, taking into account the deceased's wishes and what was in their best interests. They also look to the size of the estate, what the deceased wanted, their testamentary wishes, the moral point of it all. Is it really in anybody's interests for this to apply and for somebody not to benefit in circumstances where, in one of the cases, the wife had booked the flights and technically that is assisting. But really, is that in anyone's best interests to prevent somebody from benefiting because they booked a flight because that's what their most loved one wanted them to do? So there is a sort of discretion that the courts will take into account when deciding that whether the forfeiture rule should apply.
In terms of assessing capacity as well, these are huge decisions. People how does that factor in to proceedings? People's assessment of capacity?
Yeah, so ideally, one of the sort of more practical steps you can take, if you like, in inverted commas, is getting a capacity assessment and making sure this has to be a capacitous decision. The new assisted dying bill that's before the Parliament has a number of safeguarding provisions drafted into it. There's a debate as to whether those safeguardings go far enough, but one of those is sort of capacity assessments and whether somebody is making this decision on a capacitous basis. That in itself can be quite tricky because people have fluctuating capacity and what somebody wants on one day might not be what somebody wants on another day. And so that is in itself a challenge that needs to be thought about.
So what are some of the key points from the proposed assisted dying bill? People might have seen it in the media. What's the reality for clients?
We don't know at the moment what final form the bill will take or what it will look like in practice. But there are, obviously, I suppose everybody has seen the fors and against and people protesting either side of that. And there are safeguards. The safeguards at the moment are drafted to say sort of somebody with a life expectancy of 6 months or less. There will need to be 2 doctors' views, one of which has to be an independent doctor, and it has to be done sort of capacitously. Somebody will have to assess whether somebody has capacity or not, and it will have to have a judicial sign-off at the end of it. So a court will need to look at all of it and say, actually, yes, all of the hoops have been jumped through and we think that this person has the capacity and has made that decision free from influence of a third party or anything like that. And so, yes, they can take their own life. Some people and some commentary say that the safeguarding doesn't go far enough. And crucially, I suppose that there is no suggestion at the moment that that person who's wanting to go to Dignitas or take their own lives, etc., will have a say in that. They won't have to stand up in front of the court and give any evidence. And there's no notification, so there's no automatic notification. So there are concerns where somebody is more vulnerable and ill, that they might be increasingly isolated from their loved ones or whatever the allegation may be. And there is no mandatory requirement for someone to be notified. So your sibling isn't, or your child potentially is not going to be told that that is your decision-making process. Now, family circumstances, that might be okay. But if somebody, and you can see it if there are allegations of sort of undue influence or that somebody is being increasingly marginalised from their family, does that go far enough? Should there be some sort of mandatory requirement? We don't know. We don't know how that will look. But these are some of the questions that are coming up and why it makes it such a sort of topical debate.
And what would the timetable for that be? Would we expect it to come into law in the autumn 2026, or what kind of, is there any?
It's a good question. It missed its timescale, and so it's been reintroduced. I think the challenges are still there, so we don't have to go through the process of rehearing the bill from its entirety. So we get a bit of a jump start, but in terms of sort of implementation, I'm not sure when it would be introduced.
So Sophie, just coming back to you, what are the proactive steps that a client can take to protect themselves from risk of criminal prosecution?
As soon as you are aware that a loved one wishes to die by suicide and take their own life, I would engage criminal lawyers, because we can get a download from you, the history of the matter, and we can produce a witness statement that will best protect you should anything arise further down the line. Similarly, we can arrange, as suitable, for the loved one to have their own independent legal advice, which also protects family members because it demonstrates to a third party that there's been no undue influence here and this person has been properly advised as well. We can also assist after the event, again, creating a download of what happened if a person travelled, so that we can demonstrate that there's been no acts that would qualify or amount to an offence under the Suicide Act. And we can also assist with potentially proactively engaging with the police, which is one of the factors that would tend against the police or prosecution service from prosecuting a person if you proactively report it. And we can assist on all of that. And I think the main thing in this space is to know, as a family member, that lawyers engaging in this work can operate very, very quickly. We understand that family members might be put on notice about a family member's wish to die in this way with very little time.
They might have no time, yeah.
Yeah, and we understand that. And so we can do this very, very quickly. And it just means that you are not, after the event, having to come to us and try to recall what had happened at various stages in the past, which might be very difficult to do when you're going through the grieving process.
If people aren't in London, do you travel out to see them? Do you do remote? What if people are, mobility is a problem?
We are completely flexible. Yeah. With all the work that we do, we travel, we do things remote. What we find is, particularly in these sorts of cases, is whatever a client wishes to do. Some people prefer to see us, some people prefer for us to see them, and some people prefer it completely remote. And we're flexible. It's whatever is right for the client.
Okay, thank you. And Laura, from your side, protecting against the risk of forfeiture, which you explained earlier on,
yeah.
What should the proactive steps be?
So I think a similar process to the criminal team, in that you would want to be getting sort of witness statements explaining what you're doing, testamentary wishes, giving a narrative to the background, essentially, of why you're doing what you are and the measures you've put in place, the testamentary wishes. This is all in an ideal world, and we appreciate that obviously it's a very stressful time, but if in ideal world, if you can take those steps proactively as part of the decision making process, that's ideal. Also consideration to any large gifts that are being made from perhaps joint accounts to solo accounts, potentially to the person who is involved in assisting, making those arrangements, etc., because you'll want some sort of explanation as to why those transfers are happening, that it's not sort of part of an undue influence or a grander plan and things like that.
But purely practical kind of thing, is that? Yeah.
Practical
Yeah.
considerations
Yeah.
that are being put in place to just make things a bit easier. And then also things that I think that perhaps might not be on people's radars are where you have contractual arrangements in, so life insurances, life insurance, mortgage protection, death in services, etc. Those are contractual arrangements, and they have their own terms and conditions, and that may include death by suicide. And so you need to have a thought to those, and you don't want to be dealing with the civil courts for an application that's quite expensive and time consuming, and the criminal system, as well as having to argue with the pension provider or the life insurance provider. And so having a mind to that kind of thing can also be quite useful as well. And then increasingly, we see international estates and assets held not in this jurisdiction. And so whilst we can obviously advise about the rules here, it's also very sensible to be getting advice in the local jurisdiction where the assets are held. So if you have a property in France, for example, then getting local advice from a French solicitor is also incredibly useful, because you might get an order here and you might be thinking, great, I've ticked all my boxes in England and there's no further action here, only to find that the French have their own system, which they do. And then you're going to be going through the similar process in wherever those assets are held. So having a thought to where your assets are is also particularly useful.
I would just say what happens is the criminal team will lead initially, I'd say, because that's probably the sort of the number one issue. And we do work that entirely complements all the work that Laura does. So we will work with Laura and colleagues, and we will share witness statements and ensure that we have covered sufficient amount of detail that will assist them. There are slightly different issues at play, but what we avoid is an individual who is facing the imminent loss of a loved one having to think about all these different possible legal scenarios. And so we make sure that we condense that into sort of one piece, and we do it in stages. So I will always make sure that the witness statement that I'm drafting on behalf of a client addresses everything, or near to everything, that Laura and her colleagues will need, so that it can then just be transposed in the civil arena, and it can be dealt with if required at a later stage. And so that's where the two different streams can often complement one another and avoid sort of double work for individuals.
Because for Kingsley Napley as a firm, having strong criminal and private client and the knowledge of the sophisticated private wealth side with criminal is unusual, isn't it? So that as a competence to dovetail, I think is very unique.
So we work, the last case I did, I worked with our probate team, I worked with our DisRes team and us, and it was just a very seamless joined up process. So Laura's colleagues would come in and they would advise initially on sort of the will and the structure and the financial arrangements, and then understanding sort of the framework, they could give initial advice, and then we would just be working together to deal with it from there on.
Fantastic. Well, look, great to talk to you today. Thank you so much for sharing some insight. We look forward to sharing this case study.
Thank you.